Our 9 a.m. docket.
Thank you, Mr. Shima. I will now call the case of State of Kansas versus Daisha Butler. Case number 127378. Counsel, please come forward. Mr. Meharry, you may begin your argument.
May it please the court. Peter Meharry for Daisha Butler. If I could request 3 minutes of my time for rebuttal, Your Honor.
Thank you.
This case arose out of an altercation here in Topeka between two groups of individuals. Ultimately, one individual lost their life, and my client was later convicted of murder as a result. What I would like to do today is talk about the instructional issues, because I think when you look at the instructional issues in this case, what you find is that the jury, because of those instructional errors, simply did not have the framework they needed to properly evaluate this case. And I'll start with the instructions with regard to self-defense. That was a key defense in this case. And the district court over objection gave what we commonly call a mutual combat instruction. And it's our position that while the district court did take a lot of language from this court's opinion in McCullough, it was still an incomplete instruction and would have misled the jury into how it can apply and how self-defense would apply in this case. Specifically, the district court failed to contain language within the instruction that even if you are involved in mutual combat, self-defense is still available if it's used solely to protect your life and not solely to inflict harm. That was left off, and the resulting instruction would have led the jury to believe that self-defense was not available in this case because my client never withdrew. The language in the instruction specifically states that for it to apply, the defendant has to do everything in the defendant's power to avert the killing and has to withdraw. So that omission is problematic because it misstates the law and would mean for the jury, self-defense doesn't apply here. It takes off the table a defense that my client put forth when it should not have been taken off the table. The jury still should have been able to consider that defense as it was considering the facts of this case. As that was a key defense, we don't believe this court can find that omission harmless. As I said, it was central to the case. There was a lot of discussion about the altercation between these two groups of individuals, how it started as physical altercation became a verbal altercation, but there was also continued talking, threats, etc. between the two groups. My client repeatedly stated that she felt threatened. She felt threatened for herself. She felt threatened for her child who was with her. That all should have allowed the jury to consider self-defense.
Let me ask you a question that I wasn't sure. But was her child in the house or outside?
My understanding of the facts was her child was with her.
When she shot the gun,
Initially, she came with her child. I'm not sure exactly. I would argue that the facts aren't necessarily clear on that. But my understanding is she brought her child with her. At some point, I'm not sure, she was alleged to have fired the gun. I don't know exactly that the record is clear as to where the child was at that point. But she did clearly state that she felt threatened, and she felt threatened for her child as well when she was interviewed by the police. So whether or not the child was right at her side or somewhere else during this altercation, I think the evidence is clear that she felt her child was in danger just as much as she was. And that's why self-defense should have been an option for the jury to consider. But this instruction, because of the omission, again, takes it off the table and would not have been considered by the jury.
What evidence is there that, I mean, you've explained the subjective view of your client, but what evidence would you point to that belief was objectively reasonable?
I think you have an ongoing altercation between two groups of individuals. There was a physical confrontation between them. There was continued talking, trash talking essentially between them. So I think there is this ongoing altercation that would allow for the jury to at least consider it. And the problem isn't necessarily, okay, the jury considered it and rejected it because of that reason. The problem is the jury couldn't even consider it with the instruction. And we believe the district court properly found that self-defense, an instruction on self-defense was warranted given the evidence. But then when it gave the mutual combat instruction, it essentially took it away. So we believe it should have been properly considered by the jury, but because of this instruction was not.
But I don't think I understand. What is the bottom line answer to Justice Wall's question? What is the objective? I mean, because she was shot in the back of the head as they were retreating, right?
The evidence was that the individuals were still arguing amongst themselves. The evidence was that my client fired a warning shot. And one of the warning shots struck the individual who lost their life. But I think you have that ongoing altercation between these two groups of individuals that had been physical. And there's no reason to think that it's outside the realm of possibility that would not have become physical again because of their continued argument.
Well,
Further,
but I still don't get that because, you know, I'm just wondering whether, you know, objectively, whether a self-defense instruction was even appropriate factually, because she said she feared for her life, but, and I've looked at the facts, you know, I mean, there's obviously different perspectives about what the facts were, but any way you look at it, she was shot in the back of the head. It was not at close range, right?
no, the evidence was it was not at close range.
Right. And so what, you know, how could she objectively had feared great bodily harm?
I think she could have objectively feared that because there was that ongoing altercation, as I said. The other thing I would tell the court is that if you look at the evidence, the shot was to the back of the head. It was to the top of the skull with a downward trajectory, which is consistent with the testimony that she did not fire at, but she fired a warning shot. So the evidence as far as self-defense.
But how does that, if she fired a warning shot, how is that self-defense?
Because she felt threatened. And she had a right to use some level of force. And this bleeds a little bit into why involuntary manslaughter, imperfect self-defense should have been given. She has a right to use some level of force to defend herself, such as firing a warning shot. Now, certainly the jury could have found that excessive. They weren't given that opportunity to make that decision. But she had the right to defend herself in this ongoing argument between these two individuals, these two groups of individuals.
So there would really be no difference between, you know, if there was, I mean, you're saying an ongoing altercation, but really the altercation kind of ended because they were retreating.
I would argue it wasn't ended until the shots were fired, because there was an ongoing altercation up until the time she fired those warning shots. So when she fired those warning shots, they were arguing amongst themselves still.
What facts in the record are you relying on?
The testimony from multiple witnesses that said there was continued trash talking between the two groups of individuals. Ms. Brown testified that there was arguments between the two.
So trash talking, you can kill somebody if you feel in fear of trash talking.
If you feel your life is in danger.
How is that objectively fear? You know, what I don't get is, okay, even if they were like my son does, as he's retreating, spouting off, then you're saying that's objectively, that evidence is objectively justifies fear of great bodily harm?
It could, it depends on the circumstances. I think here she had that right to defend herself, given those circumstances. And at the end of the day, when you're looking at whether or not self-defense should be given, we're talking about some evidence, a very low standard, because this is a factual question and we want to put it in front of a jury. We want the jury to decide these facts because they're the one listening to the evidence, looking at the witnesses. So they should be deciding these facts. If there is anything that can support it, and we believe there is, and the district court did, and that's why he gave it.
Different. Now you're moving to something else, but I mean, this is, this claim of error is, we're looking at whether isn't that a matter of law, whether it's objectively reasonable?
I think if there's any evidence that could support that finding, that is sufficient. I don't think this court can say just point blank, we're deciding this issue.
No, I know, but is there evidence to support? Right. I mean, I guess that's what I'm saying too.
Maybe we're talking past each other. I don't
Okay.
know.
Go on with your argument.
Sure.
I'm sorry.
My point is simply that there was evidence for the self-defense. And that is a question then that should go to the jury. But with the mutual combat instruction, what the district court gave, it then took away because it misstated the law on mutual combat such that self-defense would not have been considered by the jury when it should have been.
While you've got a couple minutes left, can I focus you on what's giving me some problems, which is the sufficiency argument? I understand there's no evidence that she knew the victim was under 18, right?
That's correct.
And so what's your argument on the sufficiency issue?
The argument is, number one, she didn't know. She had no knowledge. And she wouldn't have reason to know under those circumstances. This was a fight that occurred late at night. This was two groups of individuals that had been essentially texting back and forth throughout the day trying to set up this fight. I think the logical conclusion is this isn't a child. This is an adult that's looking to get in a fight along with her friends, and we're going to set this up. And at, I don't know, it was like 11 o'clock at night. We're going to meet up and have this fight. So I think when you look at,
I mean, this isn't a strict liability crime, as I view this. So she's 17. I think somewhere in the record we found that she was 17 and 3 months. So what's the evidence? I mean, I'm trying to make your argument, frankly, but I'm trying to say but I need you to confront what evidence there may be that's counter to your position, which is there any other evidence anywhere that closes the gap of that 9 months in terms of what would indicate to your client that this victim was under 18?
I don't think there is that evidence that would tell my client you're dealing with a minor. The evidence here, again, was that she was full participant in this with this other group of individuals. My client didn't know her personally in any regard. So I don't think there is that evidence that she would have a reason to know that she was a minor.
Is it reason to know? Or is it that a defendant acts recklessly when the defendant consciously disregards a substantial and unjustifiable risk that certain circumstances exist?
Well, I would think knowing, consciously disregarding an unsubstantial risk.
A risk that she was under the age of 18?
You would have to consciously disregard that. You would have to have some reason to know, hey, she looks, she's 5 years old. That, obviously clues. You have to have something that would tell you that she is a minor so that you can then consciously disregard that risk. Because the risk, child endangerment, what it focuses on is putting children at risk. And that's the risk you have to consciously disregard. That not just that you're creating a danger, but that you're putting a child at risk. So to consciously disregard that risk, you have to have something to tip you off that, hey, this is a minor, maybe I should back away or whatever the case may be.
She had her 3-year-old with her. That's a minor.
That was never the state's theory that she put her 3-year-old in danger. The theory always was, and the felony murder was based upon child endangerment of the individual who lost their life. Whether or not the state wanted to get creative in charging, they did not. But their charge in this case was based on putting the individual who lost her life in danger. And that requires something to tell my client, hey, she's a minor. Otherwise, you don't have sufficient evidence for that charge.
Can I ask a question? So this sufficiency of the evidence argument is based on an assumption that the statute itself requires that knowledge element, the intent element, here it's reckless, to apply to the child's age as well as the situation in which the defendant is putting her. Could you talk about why you think that applies to the child's age, particularly in light of the instruction that the jury received in this case? So I'm looking at instruction number 13. And it would not suggest that any reckless or any level of culpability applies to the age requirement.
I think it does, because the purpose of the statute, it's not just creating, as I said before, it's not just creating risk. It's creating risk for a minor. That's the purpose of the statute. So I think it does require some level of knowledge, some reason to think that you are dealing with a minor and you are putting that child in danger. It's not just about, okay, there's a minor and there's a danger. They're married by this statute, and you have to have both, I think.
And the authority you rely on for that, would you point us to a Kansas case? I think you have Herndon and.
Yeah, there was certainly the, I want to say it was the Herndon case. I think that was the Court of Appeals case. And then there was a case, Patilio, I'm butcher the name, Patilio out of this court. Herndon kind of said, or it could have been read to require actual knowledge of the age of the minor. This court said, no, it's not actual knowledge that is necessary, but some reason to think, reason to believe that you are dealing with a minor. So again, I think that is a requirement and that is lacking in this case. And without those, there's insufficient evidence for the child endangerment conviction as well as the felony. There are no other questions. As I said, we believe that the errors and instructional errors, along with the other issues we've raised, require a new trial in this matter.
Any other questions? Thank you. May proceed, Ms. Lipscomb.
Thank you, Your Honor. May it please the court. Again, this is Jody Litfin, representing the state. I can start with the sufficiency of the evidence claim. It's our position that when we look at this in the light most favorable to the state, that we did have enough evidence here to convict of the felony murder based on the aggravated and endangering a child statute or underlying inherently dangerous felony there. We would disagree that actual knowledge is required. And I think that the Herndon case does lead, there's some language that can be read, but I think Patillo takes care of that where this court says, no, you don't have to actually know. So we don't have to prove that the defendant knew that NM here was under 18. But I think there was language that she had a reason to know, or the court just went back to the actual statute, which says, you know, a conscious disregard of the substantial and justifiable risk.
Does that mean the state could prosecute someone if the victim were 20 years old under an argument that they look younger?
I think this, I don't think it could go that far, Your Honor, because the actual.
Why is it that far? I mean, the evidence is going to be whatever the evidence is. And so can you make the argument just based on physical appearance? And so your victim's 20, but their physical appearance makes them look much, you know, below 18. And I'm not sure what that is, but it just does that. Can you prosecute somebody for that?
I don't think it would meet the element of having the victim be less than 18 years old. That's required by the statute. So no, I don't think that that works because it doesn't meet one of the elements of aggravated and endangering a child, which is the child has to be less than 18 or, you know, less than 18 years old, under 18 years old. I think it works in this case though, because she did see the appearance, and the appearance is that 3 out of the 4 of the first group of females were minors. If you look at them in the Axon videos, they look young. I mean,
I've watched all those videos because I'm concerned about this issue, and I'm trying to figure out I looked at those young women and remember, we're just trying to close a 9-month gap because you've said if the victim's 18 or above, you don't get to prosecute here. So we're trying to close a 9-month gap. I've looked at the photographs of the victim laying there on the slab, clothed. And then I've watched the body cam of the 2 young women as they were taken into the police station, I guess. I mean, we're really just going to throw these videos up there and say, jury, figure out what their age is or what a person would think. And that's a question of fact that only the jury gets to decide without question.
I think so, Your Honor. I mean, I think that's definitely a thing that the jury can determine here and should determine here based on the evidence. They can use, of course, common sense and their life experience to know whether or not these women appeared under 18 or not. And if I can point the court to.
So let me ask the reverse question of Justice Biles' question. As I understood it, he was asking about possibly prosecuting a young, a person who was not a minor who appeared young. So the reverse is a person who is a minor who appears very old, let's just say. And, you can go to any Little League game and see 16-year-old boys that may look 25 potentially. In that situation, what is the threshold of evidence that's required? You have a 16-year-old who looks like a 25-year-old man, let's say. Can you prosecute that even if the evidence all suggests that a reasonable person would not have just sort of assumed that that person was a minor?
I mean, I think we're talking about a lot of things that are very factually.
Well, but that's the point. Is this a fact question? And if it is a fact question, what is the precise fact question? Or does the statute effectively make the age of the victim is going to be a fact that probably is not going to be in dispute after everything's said and done. You can pull the birth certificate, right? Is that element effectively strict liability in this statute?
I hadn't thought about that, Your Honor. I don't think so.
Then what is the precise factual question?
Well, and
because I'm struggling to frame it in my mind. I don't know how to ask the question that the state has to prove. If it's not actual knowledge, could let's say you win on that question. It's not actual knowledge. Could a defendant in a future case argue to the jury, look, it was not reasonable for an objectively reasonable person would not have thought this person was under 18. Is that what the statute requires?
I think that would be one way to go about arguing.
Well, but what's the right way?
I don't
From your
know.
perspective.
Honestly, Your Honor, I hadn't thought about that like in a strict liability sense. But when we're looking at the sufficiency, my view of it was when we're looking at the sufficiency of the evidence, if we don't have actual knowledge, which I think is in a lot of cases, right? You see the child, usually actually I shouldn't say usually, but in cases where we're not dealing with 16, 17-year-olds, you see the child, there is actual knowledge.
Well, right. So the issue doesn't come up, but
right.
Here the issue has come up. Often should we be informed at all by the numerous other statutes in which the age of a victim is a relevant fact, which are effectively strict liability? There are numerous statutes that impose either separate crimes or enhanced crimes based on the age of the victim. And it doesn't matter. If you do these acts with the requisite intent, it doesn't matter that you didn't know or even that you were tricked into thinking the victim was older. Is there any relevance?
I guess maybe I would answer that. And is it a reckless crime? Or are we talking about intentional crimes? Maybe that would make a difference. If we look at what we're focused on here, it's the recklessly disregarding the risk that this is a child, right? And shooting into the child. So I don't know if those statutes deal with intentional or knowingly versus recklessly. And I think if you shoot a gun into a group of 4 women that look young, that's disregarding a substantial risk that some of these females are minors.
The jury instruction, though, was specific to this victim, to NM. It didn't just say that somewhere in the group there might have been a minor. It's specific as to NM. That's why I'm kind of laser focused on this. Let me see if you can make me feel better about this exercise. Is there anything else the jury would have had to tag this victim as being under the age of 18, other than physical appearance?
Yes, Your Honor. What I've listed in my brief was, I want to say it's Carmel Brown's interview with law enforcement and then her testimony later. And Carmel Brown and the defendant were, my understanding of the evidence was, is they were close friends, like family. So Carmel Brown repeatedly references at least NM as the little girl that was with them, two of their little friends. She makes several comments about.
But she's never asked whether she spoke with the defendant about that. Okay.
That's true.
Maybe you've got evidence that that other woman thought these were minors. Somehow we've got to tag the defendant with this.
Right, and I guess where I go with that is it's the state's position is that's a reasonable inference that if Carmel knew that these two, little girls, or when the little girl fell or the little girl dropped, so did Butler. They've been around each other, and I think there was some evidence of, I think Carmel Brown says they do this all the time. They're constantly fighting with each other. They're beating up their mother, or there's a constant sort of tension between all of these people, between family members. So I don't think this is something that happens. This was the first time this has happened. So I think it's just a reasonable inference to know that if Carmel Brown says that all of this happens all the time, they're all kind of fighting and walking away from each other and then fighting again. I think it's a reasonable inference to know that the defendant also knew that these friends were minors as well.
But did Ms. Butler made some statement, I think, to law enforcement that, can you confirm in the record, did she say something along the lines that I wasn't sure whether that victim was 16, 17, or 18?
My recollection was, I think she asked the detective how old she was. I don't know if she said, I didn't know. I think she said, I didn't know who they were. I didn't know their names.
Okay.
And I don't know if she specifically said, I don't know their age, but I think she said, I didn't know them. I didn't know who they were. And I think she asked how old she was, but I could be mistaken on that.
I guess I'm just trying to figure out how you consciously disregard a substantial risk toward a minor. Maybe I'm asking the same questions the other justices have, is what is the evidentiary threshold for that?
Yeah, I don't know that I have a good answer of here's where it is. I'm just throwing all of the facts that we had here to meet our burden that there was sufficient evidence based on those facts and reasonable inferences therefrom. Also, one thing I wanted to mention, I'm not sure if she was there at the time, but I think the first group of females got a ride there. So I think there was even evidence that they either didn't have a car or couldn't drive. So that was something else to throw in as well, where the second group of people did have a car and did show up and were driving. And I think that's everything that I've listed in my brief as far as what we've got to support the sufficiency of the evidence here. I didn't have any other further presentation unless this court wants to direct me to a specific issue.
Any questions, colleagues?
Since there's time left, I'll ask my thought experiment question. There are also statutes that make it a crime to commit violence against certain classes of people. I'm thinking in particular of law enforcement officers, judges, attorneys, community correction officers, etc. And I'm just wondering if does the offender in those statutes have to know? Does the state have to prove that you knew that this was a community corrections officer? As I read the statute, there isn't a requirement. I mean, it's just if you did this and victim was a community corrections officer, you're guilty.
And Your Honor, I don't have those statutes in front of me, so I don't know. But
Sure, and I know I'm reaching, but like I said, you had a few minutes left.
if it's not like the thing that's coming to my mind is flee and elude, where they have to be in a marked car and they're running, you know, like that sort of thing. But if there's not that there, I guess again, you would just argue reasonable inferences that they did know that this person was a.
So you're conceding that under those statutes, the state has to prove that the defendant knew.
I don't know that there's a requirement for actual knowledge. I don't know that I can.
But the jury
Concede that.
instruction told the jury they had to decide that. Because they focused on that victim.
The jury instruction says the defendant recklessly caused NM to be placed in a situation where her life, body, or health was endangered. And I think we've got that. I think shooting someone in the back of the head is endangered. But the risk is not tied to her alone. So I guess we just got the standard definition for, you know, a defendant acts recklessly when the defendant consciously disregards a substantial and unjustifiable risk that certain circumstances exist, or a result of the defendant's actions will follow. So I'm not sure if that's what you mean in tying the risk of being a minor to having her actual health, life, and body be endangered.
Well, item number 2 under, and I don't know what jury instruction this was, it was the aggravated endangering a child statute. It said that one of the elements was that the victim, NM, was less than 18 years old.
Yes, that is element number 2.
Anything else, Ms. Lifton? Colleagues, anything else? Thank you. Mr. Meharry, you reserve 3 minutes.
Thank you, Your Honor. May it please the court, just a couple quick things. As far as, I know Justice Wall asked about my client's statements, and on page 10 of my brief, I do list out some of the statements she made during her interview. She stated that she did not know the females at all. She did not even know all their names. And that's volume 19, States Exhibit 1, roughly 1850 to 19-minute mark. And then later in that interrogation, she did ask how old the victim was in this case. And that's about, again, States Exhibit 1, about the 4740 mark. So she did make statements indicating that she didn't know who these people were. She was there with her friends in this fight without a clear understanding of who was on the other side. And I think that shows that there just isn't that evidence for her that she knew had any actual knowledge, and also that there's no reason to think these were minors. And that's certainly the argument we've made in this case. And we do think it is required under the child endangerment statute, whether or not it's actual knowledge or reason to know. The purpose of the statute, I think, is fairly clear. It's to punish people who put minors in danger, whether or not that's a certainty of danger or a possibility of danger. And it's focused on, for that reason, protecting minors.
Could you address some sort of the thrust of my questions, which were looking at other statutes which create classes of victims? And at least it seems to me that we have not previously required either actual knowledge or even a lesser should have known standard. It's just the statute creates these classes of victims. And if your actions, whether intentional or reckless, impact this class of person, you're guilty of this crime.
As far as I know, that is true. That I don't know that there are cases where this issue has been brought up where it's battery of a Leo and the person says, well, I didn't even know he was an officer. He just, for whatever reason, broke into my house. Maybe he was serving a search warrant or something like that. And I defending myself. I don't know if there's a case out there like that or not. But I think the statute here, it does require, as far as aggravated child endangerment, it does require reckless conduct. And that requires a conscious disregard. And I think when you read the statute, that conscious disregard is the consciously disregarding the danger you are putting a minor in. That is, I think, fairly clearly the focus of the statute is protect minors from being even put in the possibility of danger, and to deter those people from doing that. And, you know, if they don't know they're minors, you aren't really going to deter them with the statute. So I think there has to be something.
I'm sorry.
Go ahead.
I didn't mean to cut off your argument. But it made me think, if that is the purpose of the statute and there's any ambiguity, wouldn't we want to tie reckless to the conduct and not age?
I think you have to tie it to both. You know, you have to have reckless conduct putting a minor in danger. As I said, I don't think you can separate the danger and the minor, because that's the point of the statute. It's that the minor is in danger here. Not just that random Joe is in danger, but, you know, a 5-year-old is in danger. You know, we see it oftentimes when somebody's charged with DUI and child endangerment because they have a kid in the back seat of the car. Don't put the kid in the back seat of the car. I mean, don't drive drunk either, but don't put the kid in the back seat of the car. That's the point of the statute.
But if the driver didn't know the child was back there, you're suggesting that would be a defense?
I think I'm not sure how that would work exactly. But I mean, my car tells me when I put a McDonald's bag in the back of my car now. But if the defense is, I didn't even know a kid was there. Maybe the kid's in the trunk. I don't know. But I think you have to have some reason to know, if not actual knowledge. One of those. So if you actually don't know a child's in there and you don't have any reason to know a child is in there, I think that would be a defense. At least to, obviously, the child endangerment part. DUI, you're on your own. But I think when you look at the statute, that requires either actual knowledge or some reason to know that a child is being put in danger by you. And here we don't think there's that evidence. For those reasons, unless there are questions from the court, we would again ask this court to reverse this for the reasons stated in our brief.
Any other questions, Ken? Thank you, Mr.
Thank you.
Meharry.